The impudence, the audacity, the unmitigated gall of those knuckleheads of liberty podcasters, daring to voice opinions outside the mainstream of accepted thought. Listen if you dare. It's angry, it's funny, it's even sometimes sad, but it's always based on freedom and justice, as you will see. Here's our host, Jason McPhee.
It is March 27th, 2023, and welcome to the Knuckleheads of Liberty, where we are bringing you the people and the organizations fighting for liberty across the country and in your region. And today our special guest is Jim Burling, and he is the Vice President of Legal Affairs at the Pacific Legal Foundation. And so they essentially are out there fighting the fight in court for all of the wrongs that the government is trampling on your rights. They're out there facing that stuff down in court. But before we get into any of that, let me introduce you to the rest of our panel. In our upper left-hand corner, we have Leon, the word Brathwaite, last word in liberty. He is a retired engineer in the state of California. In our lower left-hand corner, we have our screaming eagle of freedom, Tim Everett. He is a pilot in the state of California. In our upper right-hand corner today, we have our special guest, and that is Jim Burling, and again, of the Pacific Legal Foundation. And my name is Jason McPhee, and I'll be your host. So, let's see, our invisible hand, can you bring up the visual, because we're going to introduce people to the Pacific Legal Foundation. So here is their website, pacificlegal.org, and they are, again, like I said, fighting the fight for you in the courts. And at this point, I'm just going to hand it over to Jim to tell us a little bit more about what you guys do, what your organization is about, and how it got going.
Well, thanks. So Pacific Legal Foundation got its start 50 years and a week ago in California, and some members of then Governor Reagan's team had been engaged in some serious welfare reform in California. And what that meant was that they were going to give more benefits, but to fewer, more worthy recipients. When that happened, all kinds of people came out of the woodwork claiming to be the public interest. And this public interest lawsuits were filed one after another to try to stop Ronald Reagan's reform project. And Ronald Reagan tapped some of his best attorneys in the state of California that worked for the state to defend the reform project, the welfare reform project that Governor Reagan had. And during that process of defending the welfare reforms, they began to ask themselves, what is this public interest movement? Who are these people that are claiming the mantle of public interest for themselves, when really we think that they are not advancing the public interest? They're making the welfare bureaucracy worse by these lawsuits. And why don't we really find an organization that can go to court and defend public interest law, the public's interest, if you will? And that's when they came up with the idea of a brand new public interest law firm, because there's nothing like that existed 50 years and a week ago. So they tapped some of those same attorneys, and they started Pacific Legal Foundation with 2 attorneys, a secretary, a telephone, and a desk. And that was how we got our start 50 years ago. And from then, that time forward, we have litigated on behalf of individuals and all kinds of small business organizations to defend their economic rights, to be opposed to certain types of affirmative action, to defend the right to earn a living. And we have been going strong for 50 years with these cases.
You know, one of the things that struck me too is when you talked about public interest, that sounds suspiciously like what we hear now, the public stakeholders. You know, we're constantly hearing everybody talk about stakeholders have all these interest in businesses and everything that really have nothing to do with the company, but it just seems to be some kind of invented concept. Is this sort of kind of parallel to what you're talking about?
There are certain parallels here. The idea of the stakeholders is, of course, giving people who don't own a business an alleged right to decide how that business operates. Or if you own property, stakeholders, i.e. your neighbors or environmentalists, help to determine what you're going to do with your property. And that's just a perversion of the traditional understanding of what property is and what rights in property is and what rights in businesses are. So we think that the idea of public interest cannot be co-opted by one side of the political spectrum or another. There are different public interests. There are those public interests in favor of more welfare. There are those public interests in favor of environmental rights. And there are public interests in favor of economic rights, in favor of free speech, in favor of the ability to use your property for purposes that you think will bring you the greatest satisfaction. So public interest, when they first had the idea of public interest law many decades ago, it was initially something that the left thought they owned. When I was in law school, this was over 40 years ago, I had a professor who was very upset about hearing about these new public interest law firms who were not defending the rights of the left, but were defending conservative interests of businesses, of individuals, property owners. And he thought, what a perversion of the idea of public interest law. And I immediately raised my hand and said, this sounds wonderful to me. How can I find out who these people were? He was not pleased with my question, but it marked me on the career that I've had for the last 40 years.
But isn't a lot of these public interest, stakeholder interest, whatever you want to call it, is it, you use the word perversion, isn't that a sort of perversion of our federal constitution, though, in some of the things that they are seeking?
Oh, absolutely. Our Constitution says private property shall not be taken for public use without payment of just compensation. It's bedrock principle. And yet people think that your private property can be used for all sorts of public reasons other than your ownership of that property and by the individuals who own it. And I completely agree that the idea of the public interest is much more of a socialistic concept in some circles than what I consider to be the public interest, is what John Q. Public wants and needs within that John Q. Public's constellation of rights, not rights that are taken away from some people and given to others.
It's funny too, when you were mentioning the like your experience in the college, hearing the professor first talk about this stuff, that kind of brings me to the one of the questions I like to ask all of our guests, and it's sort of, what was it that first woke you up to these ideas on liberty? Was it something that you heard in college? Was it maybe parents, something?
How did I become woke? That's your question.
Woke in the right way. Yeah.
Okay, so here it is. Before I was a lawyer, I like to tell people, somewhat tongue in cheek, a productive member of society. Right? I was a geologist, and I spent a number of years climbing up and down hills in the western United States looking for mineral deposits for a mining company. And I loved that work. I enjoyed it. I loved the outdoors. I loved seeing mountains, and I loved digging in the dirt, looking at rocks and breaking rocks open and finding out what's there. It was wonderful stuff. But I ran into federal bureaucracy right and left as areas were being set aside for wilderness areas. And I began to rethink a lot of the things that I'd been taught going to school in the East Coast, where I was taught the traditional, very liberal values, the McGovern type of thinking. I read the New York Times and I actually believed what I read, religiously in the New York Times. And so becoming a geologist and running into federal bureaucrats, I realized that the government was not being very helpful. The government was not advancing the public's need for mineral resources, which I felt were very important. And I remember one time in particular, I was dealing with some mining claims that I had staked in New Mexico. And we were in a national forest, and you could stake mining claims in a national forest. And I made sure that a piece of every mining claim, which is a 600 by 1,500 foot rectangle, would be on a dirt road. Because in New Mexico, they had a rather old law, didn't make a whole lot of sense, but we had to follow it, that for every mining claim you stake, you have to drill down a hole 10 feet deep in order to have the dirt from 10 feet or the rock from 10 feet down below the surface to prove that you've actually done some exploration there. So I went to the forest ranger and I said, we want to be drilling these holes. We're going to get a pickup truck. It's going to have a little trailer behind it with a little tiny drill rig. We're going to punch 10-foot holes down. We're going to cover them up and we're going to move on to the next one. We're not going to go off the dirt road. We're not going to go off into the marsh or anything like that. And the forest ranger said, no, can't do it. And I said, what do you mean we can't do it? It's our mining claims. Under the mining law, we have a right to do it. He said, no. Tell you what, the problem is this is a proposed wilderness study area. And I am decreeing, essentially, as a forest ranger here, that there will be no mechanized commercial activity on my road in my forest. Get that, right? It didn't belong to him, it belongs to the people. And I immediately called my boss that evening, and I had to go home, go to the motel actually, and find a phone and call him and said, look, this guy has no right to do this. We could sue him. And my boss said to me, you're right. He has no right to do this. We could sue him, but I have an easier way. And what we actually did was hired an outfit to put a drill rig in pieces on backpacks. They hiked it in, sat their backpacks down, put it together, drilled the hole, then they dragged it to the next mining claim, drilled a hole, dragged to the next mining claim, drilled the hole. But that put in my mind, hey, wait a minute. Why are we going through these conniptions? I really think we ought to sue. No, I think I ought to sue these government agencies. So that's when I went to law school. Because as a geologist, I saw more. I told you I read the New York Times and reviewed it. I read in the New York Times a long story about a mining project that my company had in Colorado. And I knew all about the project, and what I read in the New York Times was just pure fantasy about what the impacts would be of the mining operation. Pure fantasy, no reality whatsoever. And so I began to doubt a lot of the, what I would call the liberal orthodoxy that I had believed for so long. So I am a reformed liberal. So I'm happy to say it, and I've never looked back.
Well, who would have known too that a scientific endeavor of digging in the dirt would have caused you to unearth all of this dirt, this bureaucratic and government dirt. That
pun intended, right? Pun intended.
Yeah.
There you go.
But Jim, over your 40 years of work, what have you? I mean, most of your work now deals with the courts and filing lawsuits to try to promote our rights as Americans, liberty.
Right.
But do you believe that the profile of the courts have changed in terms of how they deal with issues of liberty? Has that changed over the last 40 years? How do you feel about it now?
I think that we have the best court system that we've had in my lifetime right now. I think that we have the best chances of getting good precedents at the Supreme Court than we've ever had. When I first started working as a lawyer, there were certain ways that the federal agencies would operate, or that local governments would operate, that I felt were unassailable. There's nothing we could do about these. This is precedent that had been going on for years, and it was just impossible to undo any of this mess with a bureaucratic state, with certain ways environmental regulations are being interpreted, the powers that agencies, local, federal, and state were giving. And in the last decade or so, especially the last few years, that has really begun to change. And it's made me a great, and I use this term deliberately, a great temporary optimist. I have great temporary optimism about where we are in the courts today. There are things that I thought we could never challenge. When I went to law school, we learned that the Commerce Clause meant whatever the federal government wanted to regulate, it could regulate because it could find some remote connection to commerce. But in the last 15, 20 years, we've seen a number of cases that have called that into question more and more as we go along. I never thought I would see the day where you would have a congressional statute giving authority to a federal agency where the courts are going to say, but wait a second, just because the agency says the law gave us this power doesn't mean it's so. Let's read the words of the statute. My God, what a concept. Read the words of the statute. And so we have tremendous progress in the courts now. And I'm very temporarily optimistic.
Well, why you use the word temporary though?
I'm using the word temporarily deliberately because I'm also very concerned what I see going on in law schools today, how new lawyers are being educated in our law schools. Are they given the same respect for liberty and free speech and equality I'm not talking equity. I'm talking about equality of opportunity that we were instilled with when I was in law school. Yes, I turned out to be significantly more conservative and liberty oriented than my typical classmate in law school, but there was still room for me in law school without being pilloried for expressing my opinions. Yes, I got a few snide remarks from some of the law professors when I would express an opinion in class, but I was good with that. They let me express my opinion. I'm not sure that's true today. And I'm not sure that when we're looking at what the courts are going to look like in another 15 or 20 years, it's going to be as liberty loving as some of our courts are today. I mean, I'm looking beyond just the current administration that would, if it gets its way, would appoint others or pack the court or that kind of thing. But I'm thinking more fundamentally of what kind of attorneys are going to be out there litigating if a conservative judge can go to one of the preeminent law schools in the country and get heckled down for what? For not even being able to speak. So
as we
that's where
just
my
saw at
concern
Stanford. That
Yes.
Are you referring? Yes. Okay.
Yes.
Yeah.
Yes.
And for those of you who aren't aware, this was something where they literally had a diversity and equity and inclusion dean come in and essentially berate the federal judge who'd been invited to talk to the students of that college. It just,
Right.
I mean,
Yes.
it's like we're living in clown world here in California.
Yeah,
Without
but
a doubt.
it's worse than clown world. It's when I grew up, clowns were fun loving and the kids enjoyed them, and then clowns have turned into horror show animals, and this is a horror show clown world.
Yeah.
Yeah. Well, that does bring up the question too. It seems like this clown world is expanding to all sorts of different venues. What kind of cases? What's the sort of the range of cases that you guys pick up? What kinds of topics are you guys defending out there?
Oh, we're defending assaults on liberty right and left, whether it is provisions to prevent you from evicting non-paying tenants and rental property, whether it's people that are getting fired because they are or not adhering to the political correctness. They don't want to sit through the struggle sessions that are being imposed upon them in some places. It is people that are simply trying to make a living, but licensing requirements make it impossible. And various property right cases. We're challenging the federal government's regulation of wetlands because we believe that regulation goes beyond what the Clean Water Act allows and what the regulations allow and what the Constitution actually allows when we talk about Commerce Clause and what commerce the government can regulate. We're representing little old ladies who have lost all their property through foreclosure and getting nothing back in exchange. We're representing an individual fighting the Forest Service in the woods of Montana when the Forest Service is invading his property with a public road that shouldn't be public. So we have an endless stream of cases that we have.
So Jim, unfortunately, race and ethnicity is infecting everything in our society today. Are you all fighting any cases involving these sort of things?
We have a number of cases that we're focusing on right now on schools in the East Coast. New York City, Stuyvesant School is a wonderful school for gifted students. This is a school that has put out over a dozen Nobel Prize laureates. I just heard a talk given by a graduate of Stuyvesant High School who talked about the poor and penniless people that went to New York City, learned English, were brilliant, got into the school based on their merit through admission tests, and went on to win Nobel Prizes. The woman who gave this talk herself, her father came from North Korea. Her mother escaped from Red China, and together they instilled a great love of liberty in her. She excelled, went to the Stuyvesant High School based on merit, based on her ability to pass a standardized test. But now New York City has changed the rules. As one school administrator who was going through the school looked at Stuyvesant and she said, and I quote, "This looks like Chinatown to me." And so what that means is there are too many Asians. And as this woman said, who is a graduate herself, she said, it's like telling the Nobel Prize laureate that I referred to, who came over from Holocaust Germany, eventually made his way to New York City. It's what if they said there are too many Jews because they had a disproportionately high number? And the point is that people should be able to get into a school like this based on their hard work, based on their ability to ace tests, based on their ability to excel above their peers, not based on their zip code, but now, or their race. But now that's what New York City is trying to do, get rid of the merit-based admissions process and have a process that will ensure that there's a certain percentage of African Americans, of Latinos, and of different races, but fewer Asians. That's the important thing. And so we think that's just wrong. The Constitution says there shall be equal rights under the law, not some kind of equity DEI requirement that we have certain quotas on our schools. So we have a lawsuit that's been going on for a few years in New York City. We have a similar lawsuit in Virginia dealing with the Thomas Jefferson School. We had lawsuits in Connecticut that we won a few years ago based on their attempt. Connecticut was an extremely interesting one because they created Connecticut School District in Hartford, Connecticut, created magnet schools. And in Hartford, Connecticut's magnet schools, the idea was to have really, really good schools within the African American neighborhoods, so white students would want to come to these schools. But not enough white students wanted to come to the schools, and the local people, the African American residents, were not able to go into the school.
Oh, looks like we had a little bit of a freeze up there. Hopefully we
Yes.
haven't lost James.
But
And they're
but I
very
was just
Whoa, James, yeah, you just froze up
Yeah,
there
but-
for a second, but
I'm
so we got you back.
Okay.
But actually,
Now you're
that does bring up a point though that I wanted to mention, because you talked about these ideas that these things are just completely unconstitutional. That the idea that they favor by race, but I don't know if you remember, but I think it was 2019 or 2020 where they were literally trying to pull that language out of the California Constitution. So I think it was Prop 16, I think they called it, or something like that.
it was
And yeah, so it's like literally King's language of, hey, look, we're not going to judge people by the basis of, a government shall not, judge people by the basis of their race, sexual orientation and all that stuff. And suddenly these people want to pull that out now because they literally want to go in and judge people on all those things. So it's just absolutely sad.
I mean, California a number of years ago did have essential quota systems and these affirmatives in our schools and universities where admission would be, your ticket to admission could be based on your race, other things included, but your race could be an important part of that. And the voters of California passed a proposition saying, no way, we're not going to have this kind of quota system in California. A gentleman named Ward Connerly, an African-American who also had Irish blood, he said, look, I'm a lot of things. I'm an American, first of all, and we should be judging people on their abilities, not on the way we look. And Californians passed that overwhelmingly. A few years ago, like you mentioned, Jason, there was an attempt by the liberal left to overturn that, to go back and have the people change that. And that was rejected overwhelmingly. People in California of all races, all ethnicities, do not want to have this kind of quota system affirmative action that is the darling of the liberal establishment.
Yeah.
it's ironic. It's ironic that we had almost 100 years of Jim Crow in this great land of ours, and we fought a whole civil rights movement. The civil rights movement was fighting these sort of very same things, and now the liberal left is trying to reimpose it right under our noses. And I am so happy to see people like you and the Pacific Liberal and the Pacific Legal Foundation fighting these sort of things, because this thing is an infection that is going in a very, very bad direction.
I completely agree. Ever since I was a child, I always took to heart Martin Luther King's admonition that we should have a colorblind society, where it should not matter what our race is, that we can have white children and black children sitting next to each other in school, and it should not matter what your color is of where you're going to sit in that school, what classroom you're going to get into, or what school you're going to get into. But this seems to be the zeitgeist of the liberal left, that we really have to focus on race, because everything is now a struggle session about what our race and ethnicity is. And we can judge people based on whether we have too much privilege. I mean, I think everybody living in America is privileged to be in this country.
Sure.
But we shouldn't start breaking that down according to what we look like, and accusing people of being in the wrong race or the wrong ethnicity. It so much reminds me of what happened during the Mao years in China, where people would have struggle sessions. And if you had any entrepreneurial background in your family history, if your parents or grandparents were landlords, you were then automatically in the bottom rung of society, bottom rung of everything. And we should be punishing people for anything other than what they do and what they contribute or don't contribute to society.
James, we're coming up near the end of the show. We've got just a couple minutes here. Tim, did you have a quick question real quick?
I don't know. I got to find out where the hand raising thing is on this. But anyway, I'm the unelected gun guy of the group, and I had a question. If you are familiar with the ATF's recent after decades of having a definition of braces for firearms, rifles in particular, has Pacific Legal been involved in litigation where a bureaucracy has become a legislator and an executive and everything all rolled into one, just suddenly, like the ATF did with their recent brace ruling? Have you been involved in any litigation like that?
Well, absolutely. Not gun litigation per se, but a number of cases where we're dealing with regulatory agencies that ignore the idea of separation of powers, where they will take a somewhat ambiguous federal statute and try to turn that into carte blanche to do whatever they want. That's our wetland case that we're arguing before the Supreme Court. Does the Clean Water Act give the federal government the authority to essentially rewrite the Clean Water Act to have jurisdiction over wetlands that have no meaningful connection to a navigable waterway of the United States? There is a major case last year where we were friend of the court in dealing with the Clean Power Plan that the Biden administration tried to put in, originally Obama, then it was rescinded, then put back in. And there, the EPA was trying to adopt a regulation that would cost billions of dollars in compliance, cost tens of thousands of jobs, and shut down coal plants across the country. And the Supreme Court said that when you have such a major federal action as that, something that's going to have these huge dramatic impacts, you have to have a congressional statute that gives you express authority to do that. You can't make it up based on the the stuff between the sentences. You look at the federal law, and they're essentially the federal government saying, well, you got blank space between the sentences, we get to fill it in. And that's not correct. So, Tim, we're not involved in that case, but we are involved in a number of other cases trying to make unclear the principle that Congress will pass the laws, the executive, the president's side of things, they will enforce the laws as passed by Congress. They will not make up new laws. And of course, the courts will decide which is which.
Well, James, we're just about at the end of the show here. And so we will have you, though, on for another show. For anybody who's interested in this conversation, we're going to talk about a few of the specific cases they're representing. But is there any last quick parting shot, just a few seconds that you wanted to say? Or
I would encourage people to go onto the website that you see, pacificlegal.org, and you can learn a lot about our cases and a lot about the stuff we do and we believe in.
Awesome. Well, thanks so much for joining us on this. We're certainly privileged to have you here talking about all this, because certainly we need people out there fighting in the courts against this complete assault on our liberties that's occurring right now. But thanks so much to our audience for joining us. And until next time, stay tuned and stay free.
Yes, indeed. Okay. Life, liberty, and the pursuit of happiness, always and forever.
Thank you for listening to the Knuckleheads of Liberty podcast. Find us on Facebook, Rumble, YouTube, your favorite podcast network, and at knuckleheadsofliberty.com.